Welcome to the bench of justice.
All right, the court is calling 2019 CR 3230 and 2018 CR 2419, State of Texas versus Michael Edward Cardenas. Can I have parties announced for the record for the state?
Michael Villarreal for the state.
For the defense?
Ed Piker from Mr. Cardenas.
And are you Michael Edward Cardenas?
Yes, ma'am.
And each of the cause numbers, I'm showing you what's entitled motion to enter adjudication of guilt, first amended motion to enter adjudication of guilt, and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review those documents with your attorney? Did you understand them? All right, and cause number 2019 CR 3230, are you the same Michael Edward Cardenas? Was placed on deferred adjudication of sexual assault child on June 7, 2019 for a period of 6 years. Is that you? And are you the same Michael Edward Cardenas who was placed on deferred adjudication in 2018 CR 2419 for the offense of evading arrest detention with a vehicle on June 7, 2019 for a period of 6 years? Is that you?
Yes, ma'am.
State, are you proceeding on the same allegations in each of the motions?
Yes, Your Honor.
Defense, any objection to your client's answer be the answer for both motions?
No, I don't object. No objection to that.
All right, state.
Violating condition number 1, on or about the 31st day of January 2022 in Bexar County, Texas, the defendant Michael Edward Cardenas committed the offense of assault in violation condition number 1.
Judge, we did not agree on which one it was going to be, but I said we weren't going to plead true to that.
We'll just have him plead no.
Pick another one.
Ladies enter plea. So,
Okay. So how do you plead a violation of condition number 1? True or not true?
True.
Is it a true plea, counsel?
No, Judge.
Oh, he just played true.
Well,
Do you want him to plead not true to
I
that one?
want to plead not true to that. We can plead true to everything else.
that's fine.
All right, so state, are you withdrawing that being entered into the record, his plea of not true?
We have no objection.
All right, so state.
Violating condition number 5 in Bexar County, Texas, defendant Michael Edward Cardenas, the defendant there failed to report to the supervision officer as directed for the month of February 2022 in violation condition number 5.
How do you plead to that? True or not true?
True. Same waiver may remain allegations.
Any objections to the state's waivers?
No, ma'am.
All right, did you understand by pleading true to violation of condition number 5 in 2018 CR 2419, court could find it true, grant the motion, sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5 in 2018 CR 2419? And did you understand by pleading true to violation of condition number 5 in 2019 CR 3230, the court could find it true, grant the motion, and sentence you up to 20 years in prison and up to $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5 in 2019 CR 3230?
Yes, ma'am.
Then, and that cause number, the court will find violation of condition number 5 true. And as previously stated, the court is finding violation of condition number 5 in 2018 CR 2419 true. Is there an agreement?
There's an agreed recommendation, Your Honor, and that is to grant the state's motion in each cause, enter an adjudication in each cause, and assess punishment of 5 years confinement in the Texas Department of Criminal Justice Institutional Division. And then the state is going to take into consideration CM cause number 95488, which is the assault case that's currently pending unindicted that he previously pled true to, but then withdrew.
Defense, is that the agreement?
Yes.
Mr. Cardenas, are you asking the court to follow that agreement? I'm sorry,
Yes, ma'am.
are you waiving your right to appeal? I'm sorry?
Yes, ma'am.
All right, then in cause number 2018 CR 2419, the court will follow your agreement, sentence you to 5 years in the prison, give you credit for any time served, take in consideration CM 95488. And in cause number 2019 CR 3230, the court will follow your agreement, sentence you to 5 years in the prison, give you credit for any time served. This will run concurrent with 2018 CR 2419, and there's chapter 62 registration. Just one moment. Is there anything else from either side with regards to sentencing?
Not from the defense.
All right, in each of the cause numbers, I'm showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review those with your attorney? Did you understand them? And did you sign them? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction in each of these cause numbers, you're not allowed to own or possess any weapons or ammunition. Do you understand? If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record, Mr. Cardenas. Sometimes when people get sentenced, they think it is the end of the world because you have to do time. But you're still of an age where you can get out of prison and you can change your life. Do you understand? All right, good luck to you. Court is calling Nightback number 653940, State of Texas versus Martin Gamma. Can I have parties announced for the record for the state?
Michael Villarreal for the state.
For the defense?
Linda Corley.
And are you Mr. Gamma?
Yes, ma'am.
All right, so I see that he's currently remanded without bond because he had a new arrest. And what was the new arrest?
Judge, I think it was the deadly conduct.
It's two deadly conduct, but the same offense, same transaction.
All right, is there any witnesses from either side?
No, Your Honor.
All right, so I'm assuming it's just argument?
Judge, I just would like to introduce the two offense reports, just the one he's currently on bond for in the new case. Just state the one, we're not asking to be remanded, it's just for consideration.
Well, yeah, if I could just take a quick look.
Sure.
I think that's in there. Okay, we could just.
Yes.
I have seen. No objections.
All right, and what exhibits are they?
Safety exhibit one is the case that he is currently on bond for, that's the police report. Safety exhibit number two is the new arrest cases, the deadly conduct cases.
All right, any objection?
No objections. Judge.
All right, then states exhibits 1 and 2 are admitted for purposes of this hearing. The court will hear argument. Defense?
Judge, we do have bond set on his other cases, Your Honor. I have had extensive conversations with my client and his family. We are requesting a $15,000 bond. And if the court allows him to have this bond, and I don't know if you find GPS necessary, if we could have partial house arrest so that he can work. He does have a job. Judge, he also is diabetic and has not been eating well in jail. Highly susceptible to COVID, so we would like to give him an opportunity to bond out if possible.
All right, state.
The state's asking for no less than a $30,000 bond, Judge. The fact is that he was on bond for a case, and then he reoffends with the same victim, as well as had 2 additional victims on it. That would be the 2 new deadly conduct cases. His original bond on his case was $10,000. I think that it's appropriate that his bond be no less than $30,000 for picking up a new offense with the same victim.
Judge, we are looking at working out these cases as well. We have a plea offer that I'll be continuing to talk to my client and his family about, Judge. So we were just requesting that you set a bond. That this family's already having problems getting the money together. He has quite a few bonds, Judge, so we would ask for $15,000.
Okay, here's the court's concern. And Mr. Gamma, I'm going to tell you what I told everybody else. I don't accept any of this, as true because your attorney hasn't had a chance to cross-examine anyone. But my concern is that you were on bond for a violent offense. And I'm assuming that there was a no contact order in place. Was there a no contact order in place, state defense?
I'm double checking.
I believe there was, Judge.
All right.
Yeah,
There is.
yes, Judge.
So there was a no contact order in place. And then we come back and you have a deadly conduct case with the same complainant. So it appears that the court's orders are not being followed, and that's very concerning to me. I don't know if your attorney wishes you to speak and be placed under oath, because let me just tell you, if you raise your hand, I'm going to swear you in. And your counsel will ask questions, then the state will have a chance to ask questions. So do you still wish to give testimony to the court?
Judge, yes, I'd like to call as witness.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record, please.
My name is Martin Gama.
All right, could everyone please to whisper? All right, defense.
Thank you, Judge. Mr. Gomez, is there something you'd like to let the court know about in reference to going forward from here and being on bond?
Yes.
Go ahead. to speak up.
Yes, ma'am. My wife and I were wanting to work things out. We're in the process of going to therapy and doing everything. That's the only reason why I didn't go with the order as far as the protective order. She wanted me home to help her with my son, who's 10 months of age. We just bought a house.
How do you work out things with a gun?
That's not, that was not with her.
I mean, I'm just saying.
The gun is, the
That
deadly
was the
conduct.
Bolero, ma'am.
Hold on, Stop. The deadly conduct judge was completely separate, strangers.
Okay,
That's, so why would it be different if she let you on there?
I want to strive to be better and be a good father for my son, and a good example. I've messed up. I'm only human. I'm sorry. I'll follow the order.
okay, here's the thing. Don't do the only human thing with me, because I'm only human. There, if you look around this courtroom, there are a lot of attorneys here who are only human, but they don't have an assault case pending and they don't have a deadly conduct charge, and they're not disobeying the orders that I've given them to stay away. You understand?
Yes, ma'am.
All right.
Judge, I'll pass the witness.
Mr. Khanna, the fact is that the deadly conduct case doesn't just involve the two strangers at the convenience store, right?
We're allegedly, yes. So,
I mean, he's under oath,
yeah,
right?
he
He
needs
needs
to
to.
testify.
So,
I'm sorry, you're gonna have to speak up. And could everyone please whisper, because I'm trying to hear
Allegedly,
the testimony?
Allegedly, yes.
Okay, and then you'll agree with me also that based on the police reports, the deadly conduct also involves the same victim, right? Your wife,
Allegedly.
allegedly, right? So when you told the judge that it only involved two other people, that's not true, right?
Allegedly.
And
So again, you were on bond for an assault choking case. I'm not going into the facts. You were on bond for an assault choking case with her, right?
Yes, sir.
And then you admittedly continue to violate the order by having contact with her, right? Well, you testified to the fact that you were living with her, right? And then after that, then we have the police report for this case, right? Which has allegations in it, right? Okay. And so we're not just here for just that case too, now that you've admitted also that you were living with her and continuing to violate the court's orders, right? I'll pass it to the judge.
no further questions, Judge. I would like to correct the record. My client didn't say that the deadly conduct was just the other strangers. I did, and I had that incorrect, but that's not what my client said. Judge, for just argument's sake, my client understands that he is severely messed up. He made the wrong decisions. He had his reasons. He understands that no reason matters. You have to follow the order, do it the right way, get permission from the court. He wants to go forward, Judge. He wants to get this right. He understands the serious nature of this, and Judge, he is willing to do whatever is required to have the court allow him to bond out.
All right, so this is what the court's gonna do. State, I know you're asking that bond be set no less than 30,000.
Yeah, and judge, now with new information that he's continuing to violate the court's order, you know, maybe 30,000 not appropriate, but I'd ask them no less than 30,000.
All right, so the court will grant your motion. The court is setting the bond at 50,000. There's to be full GPS waive fees. And defense, as you know, the court does not have pre-indicted cases on the docket, but if this is something you wish to bring back, just let the court coordinator know.
Judge, would you consider allowing him to work? In order for him to do all this financial, he will need to work, and he does have a job.
Once if he's released on custody, then the court will reconsider, but for now, it's full GPS.
Thank you, Judge.
You're welcome. Mr. Villarreal, could you hand that to the court reporter?
Yes, thank you.
Thank you.
This courtroom saw two defendants facing the consequences of broken trust, and Judge Boyd made it clear, second chances don't last forever. First, Michael Edward Cardenas stood before the court after violating probation tied to serious charges, including sexual assault of a child and evading arrest. Despite being given deferred adjudication, he failed to report to his probation officer. When he pleaded true, the consequences were immediate. The court accepted a plea deal, 5 years in prison on each case, running concurrently. What started as a second chance ended in a prison sentence, along with lifelong consequences like sex offender registration. Then came Martin Gamma, already out on bond for a violent case. Instead of following strict court orders, he allegedly reoffended, this time involving a weapon, and even the same victim. His defense argued he was trying to fix his family, but the judge wasn't convinced. Violating a no-contact order and picking up new charges showed a dangerous pattern. The result? A steep $50,000 bond and full GPS monitoring. 2 cases, 1 message. Ignore the court's trust and the consequences escalate fast.